Good afternoon, everybody. Welcome back. Hello, Instagram. Hello, YouTube. We're all here, and we're going to dive right in. This is our nuts and bolts series. We're going to talk about timelines, what to expect along the timeline of your case. We get questions. Let me fix the tie here. There we go. We get questions all the time about how long does my case take? What should I expect? Why should I put my phone on Do Not Disturb? And that's what we're going to talk about today. Timelines. Okay, so we're going to dive right in. As always, post your questions. I will try to get to all of them today. You guys have not let me down with the fantastic questions we've been getting. Last week was a home run in terms of questions that we got, and it was just a follow-up from the week before. You guys are doing great, and let's keep this going. So we're going to dive right in with our discussion on timelines. How long does a workers' compensation case take? Looking sharp. Feeling sharp. We had trials and hearings today, and we have the bar dinner tonight, so we're dressed up. How long does a workers' compensation case take, and why are some cases longer than others? Fantastic question. It's a question I deal with every single day. The timeline of a workers' compensation case can vary, and every case is different. Every case is different. I always give the example. We represented two gentlemen who were in the same motor vehicle. They were worked, and we've talked about this before. They were delivering appliances. One guy was driving, one guy was the helper, the passenger. They got into a car accident. One of their cases was uncontroverted and handled relatively quickly, and the other one was controverted and dragged on for months and months and years and whatever, and took forever to get resolved when compared to the first guy. Same accident. They were in the same accident. They worked for the same employer. Why did one take so long? Every case is different. And rather than get into the specifics of that case, just know that every case is different. Most cases can take about 12 to 24 months. Some can settle in a matter of weeks or months, and others can drag on for years and years and years. No two cases are the same. So please keep that in mind. And one of the biggest factors in determining how long your case is going to last is your recovery time. Recovery time plays a huge role. We follow your case. You don't follow us. So what does that mean? And this is a discussion I always have with people. People say, well, why is it taking so long? You must not be doing something if my case is taking too long. No, we follow you. For the most part, we follow your recovery, your treatment, the things you're going through. And that's what dictates how long your case is going to go and what needs to be done. So we follow you in your treatment. We don't push your case in a certain way. And again, these are generalities, but generally speaking, the more severe your injuries, the longer your case will probably take. Also, if the insurance company fights your case, we call it controverting a case. If they fight your case, deny an aspect of your claim, your case is probably going to take longer. It could take months to get a hearing. If a case is being completely controverted, you're not going to receive benefits, so you're not going to get any money while you're waiting for your case to be adjudicated, to be litigated, and to get a decision from a judge. So that's why some of those cases take time. Questions are coming in, and I love it. What are the main stages in a workers' compensation case, and how long does each one take? Yeah, there we go. So what are the main stages? The first stage, and this is super important. We use the acronym ANCR here in New York State. How do we establish a case? We have to prove ANCR, accident, notice, and causal relationship. So the second one there, notice is a biggie. It's second to getting hurt in the first place. So giving notice is a huge part of the process. You need to tell your work about the injury as soon as you can. Tell your boss, tell your supervisor, tell your foreman, tell the owner of the company, tell the guy in charge. Tell them as soon as possible. And if you can, do it in writing. Nowadays, we all have a cell phone stuck to our hip. Shoot your boss a text. Shoot your supervisor a text. Hey, Mike, I just fell off the ladder. My back is killing me. I think I need to go to the hospital. Beautiful. Now you've done it. You've given notice. You've just successfully filled the legal requirement of giving notice. Under New York law here in New York State, notice must be in writing. You have 30 days to give written notice to your employer and supervisor unless your employer has actual notice. So most cases, there's actual notice. Hey, boss, I just fell off the ladder, and I'm going to the hospital. Boom, you just gave him actual notice. Or your employer sees you fall off the ladder, or a coworker runs and tells a boss, Jimmy just fell off the ladder and he's in a lot of pain. That's actual notice. But why risk it? If you're within the 30-day period, give written notice. Hey, if it's already over and you're in the hospital, shoot a text. Hey, I'm just following up. I'm in the hospital waiting to get checked out after I fell off the ladder at work at 4 o'clock today. Remember? Give written notice. Check that box. Fulfill that requirement. Don't risk it, because if you risk it, it becomes a he said, she said type of situation. And look, I know you might have worked there for 10, 15, 20 years, but you never know what somebody's going to say when they think their butt's on the line. So put it in writing. Depending on your state, every state's different, as we know. You could have as little as 3 days to give notice. In New York here, we have 30 days to give notice, and your employer is supposed to notify the insurance company within 14 days after that. But 30 days is the notice requirement here in New York. But keep in mind, the longer you wait to give notice, the worse it looks, even if you're within the 30-day period. A judge is going to look at your case and they're going to say, did you notify your employer that you got hurt? Yeah, I told him. When did you tell him? I told him 3 weeks later. I called him up and said, by the way, 3 weeks ago, I fell off the ladder. Well, it's not going to look right. If your injury is that bad, you probably should have given notice to your employer, and it should have been pretty immediate. Don't wait. Even though you're within the 30 days that the law allows, do it as soon as possible. Don't make yourself look bad. Don't risk the possibility of them finding that you didn't give proper notice just because you might have been a little lazy or hurt or whatever. Shoot a text, phone call, email, let your boss know that you got hurt. I am thirsty. Stage 2, numero dos. What's the second stage? Second stage is your claim is filed and reviewed. So depending on your state, you or your employer or both might file a formal claim. Here in New York State, you, the injured worker, file what's known as a C3 claim form, and you have 2 years to file your claim. 2 years from your date of accident, or if you have an occupational disability, repetitive stress type case, 2 years from the date you first knew or should have known your injuries are work-related. We could do a whole video on occupational and repetitive stress cases, but it's 2 years from the date you first knew or should have known your disability is work-related. If you had an accident, it's 2 years from the date of accident. 2 years. But again, do it as soon as possible. Get your claim filed as soon as possible. The longer you wait, the worse it makes you look. That question always comes up when a claim is filed, 6 months even. You have 2 years. When a case is filed 6 months later, if the insurance company is going to controvert any aspect of that claim, they're going to ask you, if your injury is that bad, why'd you wait 6 months to file a claim? That's a quarter of the time that you have to file the claim, but they still will ask you because it's there to make you look bad. Don't be made to look bad. File that claim as soon as possible. Cover your bases. Be protected. This way, you don't have to face that question. Because if one aspect of your claim looks bad, you want one less thing, and you want nothing at all, if possible. You want to look good. You want to look like that this is all on the up and up, and you don't want anything to put any shadows of doubt over your case. So don't wait. Pardon me. Once your case is accepted by an insurance company, after it's reviewed and accepted by the insurance company, you should start receiving benefits shortly. Just to backtrack for a second, we were talking about you and or your employer will file a formal claim. Yes, you file a C3. Your employer is supposed to file a C2. They're supposed to notify their insurance company. Sometimes when people get hurt and they give immediate, actual notice, written note, whatever, if there's quick notice to the employer and the employer gets on the phone and calls their insurance company like they're supposed to, the insurance company does their investigation and they say, hey, what happened? Jimmy fell off the ladder. Okay, did you see it happen? I saw it happen right in front of me. He was installing a light and he fell off the ladder and he hurt his neck and his back. If everything goes the way it should, with the exception of you falling off the friggin' ladder, a lot of times the insurance company will accept that claim. And sometimes they'll accept the claim before you even file. It happens. We see it happen pretty frequently. So sometimes you will start receiving those benefits relatively quickly in short time. In New York, the insurance company is supposed to start paying you within 18 days after your employer reports your injury, unless they deny the claim. Denying the claim happens too. And they could be denying the entire claim. They could be denying a portion of the claim. If the insurance company denies the claim, usually a hearing is scheduled 1 to 3 months, but it really depends on a lot of different things. There needs to be medical evidence in the file. The board needs to do an investigation as to who carrier is, and there's a lot of different factors, but usually it's about 1 to 3 months, but it can be longer. If it's an uninsured employer case, it's certainly going to be longer. The board's going to do a pretty protracted, long-term, in-depth investigation to make sure there is no coverage, but those uninsured cases take longer. I am guaranteed on a case where there's an uninsured employer, an angry client at some point in time. Why? Because they think we're doing something wrong because that case has taken a long, long time. And they had a friend and a cousin and a buddy who had a workers' compensation case, and they already had money 1, 2, 3 months after their accident. Why am I waiting 4, 5, 6 months to even get to court? Well, it's because it's an uninsured employer case, and we have to deal with New York State defending your claim, and that's just the way it goes, my friends. So yeah, we have to deal with that pretty frequently in the uninsured employer land, but it is what it is, and I'm sorry, but it's just the nature of the process. Those things can add weeks and months overall to your case. Stage 3 of the timeline of your case is what? I might be loco here. Oh, that's number 3. It's how to speed up your case. So we're still in the stages. Stage 3. What's the stage 3 clinger? It's medical treatment and recovery, and this is the longest stage of the case. This is what usually takes the most amount of time. Why? Because like I said before, we follow you. We follow your treatment. I'm not going to rush to settle your case if you're still actively treating, if you need surgery, if your charger's flying off the table. I'm not going to push your case to settle. We follow your case and settle when the time is right. So that's why this is usually the longest stage in the process. A small injury could heal in a couple of weeks, and a case could wrap up within 6 months or under a year. Yes, but serious injuries can take 1, 2, 3 years before you're getting to the end stages and trying to look for settlements and finalization of your case. The goal is to reach maximum medical improvement, and we discussed that before. What is maximum medical improvement? It's when you've reached that plateau. You've reached the point where there's treatment. There's no more treatment to help you out. You've gone through all the treatment. Your doctors have given it their all, and they don't think you're going to get any better. And now you have been deemed to have a permanent injury, and they assess your permanent disability. The average timeline to reach maximum medical improvement, according to the New York State Workers' Compensation Board guidelines, if it's an extremity injury, those schedule loss cases that we've discussed 100 times before, those arms, legs, hands, feet, fingers, toes, is usually about a year from your date of accident. If it's a systemic core body injury, spine, head, neck, back, lungs, heart, anything, systemic, core, usually it's 2 years. And the other factor is surgeries. The surgeries reset the clock. If you hurt your shoulder, you're looking at a year from your date of accident. If 3 months 3 months after you got hurt, you go for a shoulder surgery, you're going to restart the clock, and the year is going to pick up from the day of your surgery. Why is it? Because the compensation board wants you to reach that level of maximum medical improvement. If they assess you for permanent disability while you're still getting better, well, then it's not really a true assessment. They want you to reach that plateau. And that's usually why they wait that long. Generally speaking, you're not going to look to settle your case, properly until you're approaching or you've reached maximum medical improvement. You want to be in that sphere around the zone of maximum medical improvement. That's when we really look to settle most cases. Stage 4 in the process, settlement talks, final approvals. Once you approach and reach maximum medical improvement and settlement negotiations start, that's when we start getting into the final stages here of settlement and getting you the money that you're entitled to and letting you move on with your life. Settlement negotiations often takes weeks or months, but sometimes it could be a few hours, and sometimes they never happen at all. You could send 1,000 emails, and some of my clients, my existing clients that are watching me now, know what I'm talking about. You could send 1,000 emails, make 1,000 phone calls, and you get nothing. You get crickets. I don't settle for crickets. So sometimes, and I've also settled cases in one phone call, and those are the best. Efficiency, my favorite word. Some insurance companies will drag their feet or never respond, and the problem is you cannot force a settlement. Clients ask me all the time, what's going on with my case? How come they're not settling? And I say, they're not answering me. I'm sending emails. I'm calling. I'm leaving voicemails. I've asked for supervisors. I'm going through the attorneys. I'm trying everybody. Nobody's getting me an answer. And they say, well, why can't you just get in front of the judge and force them to settle? because you can't force a settlement. You can force the case through litigation and let the judge make a decision, but you can't force a settlement. If they don't want to settle, you cannot force them to settle. The same way, if you don't want to settle, they can't force you to settle. There are circumstances where the reverse is true, where an insurance company will send me a letter, make a phone call, send me an email and say, hey, this is our offer. Settle, 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 settle. My client says, I don't want to settle. I don't want to settle. I want to leave my case open. I'd rather get my weekly benefits. I don't want to jeopardize closing out my medical. I get it, and that's fine. You cannot force anybody to settle a case. Usually, though, once an amount is agreed upon and everyone's come to the table and reached an agreement, finalizing paperwork takes a few weeks. The insurance company will usually draft. Sometimes we draft. We draft all the ancillary extra documents that go along. We review everything. All the parties make sure the paperwork is in order. We have you come in, we sign, we view the video, workers' compensation. I'm pointing to my video screen here like you guys know what I'm pointing at. Some of you do, the ones that have been here. But we watch a video that the board requires about settling your workers' compensation case. It's on YouTube. And then we submit your paperwork to the insurance company. They sign off as well, and it goes to the board. The board does their own review of your settlement documents. And once they're okay by their standards, that's when you get your settlement hearing and things start wrapping up. And those are the steps, the stages. How can you speed up your workers' compensation case? How can you get to the finish line a little bit quicker than everybody else? And number one, we just discussed it. Report your injury right away. Give notice to your employer. Give notice to your supervisor. Send that text. Send that email. Go into the safety shed at the job site. You guys who know what I'm talking about know what I'm talking about. Fill out that incident report. Fill out that accident report. Go to HR. Do what you're supposed to do in your particular workplace to report an injury. Sometimes it's as simple as sending a text to your boss, but sometimes you have to go fill out a form if you work for a large construction company. And you guys know what I'm talking about. Report your injury right away. Tell them, fill out the forms, report it 15 different times, send an email, send a text, make sure all your bases are covered. Waiting too long can delay your benefits and can get your case denied. If they see that you waited a long time, they might think something's up and they might throw a denial in there and let you have to go work it out with a judge. And even if you're within the time frames for providing notice, it still looks bad. A judge is still going to look at you with a crooked eye. Why did it take you 3 weeks to notify your employer that you got hurt? Something doesn't seem right. Why did it take you 1.5 years to file your claim? Something doesn't seem right. Even if all the other T's are crossed and I's are dotted, they're going to look at you a little bit funny if notice and filing your claim was a little bit delayed. The second thing you could do to speed up your case, make sure you use a doctor that's familiar with the workers' compensation system. I can't begin to tell you how many times, and it's not that they're bad doctors, and it's not that they don't know what they're doing, but workers' compensation is a very strange animal of its own. And if the doctors aren't familiar with the system and the forms and the evidence and how to put in requests for treatment, they could get bogged down and your case can get slowed and your treatment can get slowed down or denied altogether. And it could hamper the development and the movement of your case. Having a doctor that knows what they're doing is super important. It's hard to tell a client not to use a doctor that they're comfortable with, but the doctor's got to know the system. Having a workers' comp doctor who knows what they're doing, super important for you, your case, your treatment, and having your case move at the proper rate. Showing up to all your medical appointments and following your doctor's orders, also super important. Skipping treatment, ignoring your doctor's orders, doing things against medical advice can delay your case, can hurt you, can jeopardize your right to treatment, can jeopardize your right to benefits. Listen to your doctors, keep your appointments, and do the right thing. Gaps in medical treatment. Insurance companies love gaps in treatment. They love them. They're like these big highlights to them of, wow, this guy's not hurt at all. He didn't go see a doctor for 9 months. You might have been home in intractable pain, but a lack of treatment makes it look like you were skipping through the daisies. So don't skip your treatment. Insurance companies love big gaps in treatment. Also, don't miss IMEs. When an insurance company sets up an appointment for you to go see their doctor, keep those appointments. If you can't, if you're sick, if the weather's bad, if it's too far, if you have a doctor's appointment that day, if you have court that day, if you have a legitimate reason for not going, don't just skip it. There's a phone number on the front of every one of those forms. Call the number and say, hey, I have my own orthopedic appointment that day. I can't go to your doctor. Please reschedule. Hey, you've scheduled a doctor that's 3 hours away. Please find me a doctor that's closer, and I'm happy to go. Hey, I know I have an appointment tomorrow. I'm home with the flu, and you don't want to know. Please reschedule. That's fine. Don't make a habit out of it, because then it looks bad. There's no reason for any of these things that make you look bad in front of a judge to even ever happen, because they're in your control. It's in your control to give timely notice. It's in your control to file your claim as soon as possible. It's in your control to not skip and reschedule 800 IMEs. It makes you look bad. Don't be made to look bad for no reason, especially when you have control over it. They'll look for other things to make you look bad. Let's not add to that pile. What else can you do to speed up your case? Stay active. Okay? Don't go radio silent. Don't ignore paperwork. Don't ignore your lawyer. We have a letter called the Please Call Office letter. When clients go radio silent, when we get ghosted, I know we have a lot of younger people on here. We send the Please Call Office. Hey, we've been calling you for 3 weeks. You are not answering us. Please call us. We need to talk to you. Don't go silent. Stay active in your case. Keep up to date with your lawyer. Give them the information they need. Do what they tell you to do. Do what your doctors tell you to do. And your case will move faster, smoother, and will usually have a better outcome. Because if you go radio silent, who knows what to expect? Make sure you show up to your hearings. Please, please. Workers' comp is still virtual. You don't even need to get out of bed to attend your hearing. They're going to call you on your phone. Pick up the phone. We call all of our clients a week in advance. We text them a day or two in advance. You know it's coming. You got the notice in the mail. You know you have a hearing. And we tell them it's going to be a number that you might not recognize. And you don't know how many times people don't pick up the phone and they call my office and say, what happened with my hearing? They never called me. Yeah, they did call you. Didn't you get a number? It was a 518 number. Yeah, I don't answer a number that I don't recognize. I'm sorry. Unless you are in high levels of government or you're more important than the average Joe, pick up the phone when a judge calls you for your hearing, because if you don't, they could suspend your benefits, suspend your money, close your case, and you got to wait 2, 3, 4 months to reopen because you missed your hearing because you didn't feel like answering the phone. Answer the phone. Answer the phone when you have a hearing. Show up. That's the same as getting up, taking a shower, getting dressed, and going to court in the good old days. Now all you got to do, pick up the phone. You don't even need to go on video most of the time. Pick up the phone. The more you stay on top of your case, the faster it's going to move. The more you stay on top of your treatment, the quicker you're going to get better. The more you stay on top of your case, the faster the case will run through the process of getting you your benefits. Be an active player in this game that is your case. We're here we're the manager. You're the player. We need you to play. We need you to be involved. What else can you do? That one got me a little aggravated. What else can you do? Work with a lawyer who understands workers' compensation law. We do the work in your case. We do the depositions. We go to court and make the arguments. We write the appeals. We write the summations. We do the work. What does that mean you do? You can focus on getting better and answering the few questions that we need you to ask, sending us the few documents we need you to send, and being involved in your case. I always tell my clients, when I sign a new case, every single client says the same thing. What do I do now? I tell them, go to your doctor, get better, call me when you go back to work. Go to your doctor, get better, call me when you go back to work. That's it. That's your job. If I need anything, I'm going to call you. When I get access to your case file, if I see that there's salary information missing, I might call you and tell you to send me your pay stubs. I might call you and tell me to send me your tax returns. I might call you and ask you for the name and phone number of the surgeon who handled your surgery. I might call and ask you some information, but all you really need to do is get better, answer my few questions, and things will work smoothly. And at the end of your case, your lawyer will know how to negotiate a settlement more efficiently and get you better outcomes. We know how to press the insurance company to act faster. We know when to settle your case. We know what to avoid when it comes to valuing your case so you're not undervalued. A lawyer should get you faster and better outcomes on your case than by doing it alone or by doing it with an attorney who doesn't know what they're doing. Super, super important. And I'm not just tooting my own horn here, but these are the things that make your case move along a little better. Wow, we rambled through that one pretty quick, under a half an hour to get through my meat and potatoes discussion, which leaves more time for you. Need a sip of water here. And as always, folks, if you like what you're hearing, if I'm helping you, don't forget to hit the like button. Don't forget to subscribe. Thank you so much. All right, let's go answer some questions. Oh, I have to cough. Excuse me. So AE low key, I got hurt on 1/17/25. So we're 5 months in. I still have yet to have my first hearing. I don't know if it's taking too long or if I'm just being a worrywart. You are being a little worrywartish, but you're starting to get into that it's taking too long. But are you what's the status of your case? Are they paying you? Are you receiving benefits? Workers' comp in the last couple of years here in New York, they're trying to streamline the system a little bit. So sometimes, well, all the time, whenever a hearing is requested, pretty much on any case, whether it's requested or not, the board is now taking a little bit more in-depth look at each claim and trying to answer questions and cut through any type of disputes that can be done without hearings, because the board's trying to be more efficient. And I respect that. They're trying to save money for the state. They don't want to spend money on judges and reporters and hearing locations, and whatever they could do to save money, they're going to do, and they should do, because it's better for everybody. So sometimes you might not need a hearing. So just because you haven't had a hearing doesn't mean that something bad's happening. If you're being compensated, if you're getting the payments that you're entitled to, if you're getting the treatment that you're entitled to, you might not need a hearing. So, what we just discussed about what takes a long time in a case, those are usually controverted cases. If your case is not being controverted, then perhaps that's the reason why you haven't gotten a hearing, and things might be okay. You might be a worry. You know better than to hit me with worry wart things like that, because I'm going to trip over them. You might be a little too uptight. Call your lawyer if you have one and ask them for an explanation. And if you don't, or if anybody out there, dear folks, needs help, call me, 212-406-8989. But you know what? I like that. And because you're getting a gold star for that, because you allowed me to explain that. And that was actually a better question than you would think, because you might not be being controverted. You might not be controversial. It's Wednesday, and I feel like it's like late Friday. Butterfly in the sky. I've been given the runaround regarding treatment for my wrist. A year later, I finally got an MRI which shows torn ligaments. Is it too late to get treatment? From a legal perspective, I'm going to tell you no, it's not too late to get treatment. If your case is open and those opportunities are there for you. I'm not a doctor, so I can't say that medically it might be too late, because that's a possibility. Certain injuries and treatments need to be done within certain time frames, so I can't say for certain whether or not it's too late for your treatment from a medical perspective. But from a legal perspective, barring a case that's been disallowed, you should be okay to get your treatment. AE low key, you appreciate the work that you're doing. It's kept me calm thus far. You're doing all right. I understand if you're that type of person who worries, that's fine. But again, if you're getting your benefits, if things are going relatively okay, you might be in a better situation than you even think. Natalie, hi Rex. Who and how is the future medical calculated? Thanks. Great question, and it really depends on the nature of the case and whether or not and what stage you're at, and whether you're Medicare eligible, really. In circumstances where a person is Medicare eligible, receiving Medicare, receiving Social Security disability, that future medical calculation actually has to come from CMS, the Centers for Medicare Services. When we're working on a Section 32, under that set of circumstances, the insurance company usually works up their numbers, or they have an outside company work up what's known as an MSA, a Medicare set-aside. They estimate what the cost of your future medical will be in terms of present dollars. If you think about, if you have two two people with the exact same injury, and one of them is 26 and one of them is 86, well, the future cost for the 26-year-old is going to be a lot more than the future cost for the 86-year-old, even if they need the same treatment. It's going to be over a longer period of time. So they need to figure out the cost of your future medical in today's dollar value. And these outside companies will figure out that amount to the best, or estimate it to the best of their abilities. And then they send that off to CMS, and CMS will approve or disapprove. And that's how your future medical is generally calculated. Is malpractice common with insurance doctors? Define common. No. If an insurance doctor is not there as a treating doctor, they're there as a hired independent consultant. So no, it's not common, if at all. Peg leg. Hey, Rex, as I sit here waiting for my PPD offer from workers' comp, I can't help but reflect on how you've been here for me this entire time, always answering questions and always giving advice. That's very nice. And I appreciate that. And I hope that your PPD offer is huge. I just want to express a thank you for being here, and for not just myself, but for so many others around the USA who need some relief while going through workers' comp, the dark dungeon of workers' comp. Thank you for being a light in the dark. That's very sweet and very nice. And thank you. Thank you for the kind words. It means more than you can imagine. Those little thank yous go a long way with me. So now I'm going to cry. Thank you. My lawyer's secretary mentioned in conversation that they were going for permanency in August. What exactly does that mean? I had surgery in November, but still have major issues. I need to know what August and November you're talking about. Did they tell you this last August and then you had surgery 3 months later? Or did you have surgery last November and now you're going for permanency this August? That makes a little more sense. But if you still have major issues, make sure you talk to your lawyer and his secretary, or just your lawyer and the doctor, because there's a lot of things that could be going on here. There's a lot of things. Do you have a third party case that could play a role here? When the doctor, when they say they're going for permanency, is it because that permanency reports have been directed by a judge? A lot of factors here. So you might need to get a little sit down with your lawyer and get some clarity here on what exactly they mean and what they're talking about. Peg leg is back. That snake is pretty awesome. I've been here. My phone is covering the picture, so I have to dive and weave. It's been 2 years for me, and I've been here almost every Wednesday. You give me a purpose through all this, and sometimes Thursdays. Listen, man, anything I can do to help out, that's what I'm here for. I'm happy to help. I'm happy to help, and I'm glad that I was able to help you. Super glad. Mandu, what is that picture? That's you smoking a blunt. Of course. You made me say blunt on a legalese podcast. Hey, Rex, what's the average settlement you've witnessed for hip injuries? I know every case is different, but just the ballpark if you have one. There's no ballpark. People always ask me. And let's give an example here. A hip, a leg, 100% of a leg, I'm doing math right here, is 288 weeks of compensation, right? Okay. Now let's take a person who was earning $600 a week, so their comp rate is going to be $400 a week. And let's take somebody who's earning $1,500 a week, so their comp rate's $1,000 a week. And let's say each of these people have a 20% loss of use of their hip. So that's 57.6 weeks of compensation. Now, the other factor, so you have your rate of compensation. So $1,000, the person who's earning $1,500 a week and gets $1,000 workers' compensation rate. Well, what's that hip worth? It's worth $57,600 minus all of their prior payments, minus reimbursement to the employer if they paid your sick time, accrued time. There could be things that come out of that. By the same token, the person who earned $600 a week, that injury is $23,040 minus certain things. So, is it a hip plus a back? Is it a hip? Did you also blow out the knee? There's a lot of other factors that come into play here. So it's hard to say what the average is, because it honestly, first and foremost, it's based on your salary, and I need to know what your salary is. And then you got to look at deductions. So there's so many factors that come into play. But Ben is going to tell you that his employer doesn't have workers' compensation insurance. I'm in California. How long? Okay, the Uninsured Employers Benefit Trust Fund. So that's California's way of doing it. The Uninsured Employers Benefit, the UEBTF. Here in New York, we have the UEF, the Uninsured Employers Fund. The UEF is a fund, is an entity was created by the New York State legislature and the Workers' Comp Board to stand in the place of uninsured employers, or to stand in the place of the carriers that should be there for an employer who's otherwise uninsured. They sit at the carrier side of the table. They handle the case like an insurance company, but based upon their charter giving them the power to exist, they are required to litigate every case. They cannot just accept the case. We have to go through a trial. Who'd you work for? How long did you work there? What did you do? How'd you get hurt? What did you hurt? How much did you earn? What's your lost time? So on and so forth. So that takes time. Also, because since the state is the one holding the bag here, excuse me, they do a pretty in-depth compliance search. They make sure there's no coverage out there. They check across state lines in certain circumstances. Maybe you have coverage in New Jersey or Connecticut or California or whatever that'll cover this case. Then they want to make sure all the parties are at the table. They don't want to waste anybody's time. They don't want to waste their time, because time is money, folks. So that's generally how it works. They take longer than normal. They do. But Ben is telling me my landlord gave me 60 days notice to quit for no fault reason. Ben, I'm giving you 1 day's notice to no fault. I'm injured. How can I prove to the judge for eviction hardship? I don't do landlord tenant stuff. I certainly don't do it in California, but talk to your lawyer. If you're being evicted, if you're having those types of problems, there should be some relief somewhere to help you with all these processes that you're running through, because it's a pretty shitty circumstance you're in, and I totally get it. I'm not trying to downplay it, but talk to your lawyer. Maybe there's a some state aid or local aid that can help you out in that circumstance. I feel terrible, but I'm not licensed in California. Zoe Roberts, $1,100 a week for temporary total disability. I've been out of work for over a year for multiple body parts due to a truck accident. How much do you think my case is worth? Tibia plateau fracture, broken vertebrae, and nerve damage. All sound terrible. I've had clients that have broken vertebrae that wind up going back to work with no loss of wage earning capacity. I've had clients with broken vertebrae that are totally disabled for the rest of their lives. So just by the nature of the injuries, it's impossible to say. I need to know what your level of disability is. The list goes on, Zoe Roberts. Shoulder. There should be unless it's shoulder contusion, but shoulder concussion, hand surgery for torn tendons, skin grafts. You got banged up pretty good. There's a lot of different factors that come into play here. Do you have a lawyer? And have you had this discussion with your lawyer? Because that's really the most important person to discuss this with, to see what your values are and what you're looking at in terms of time frame. Like I said in the past, it's about managing expectations. Talk to your lawyer. Agua. Josh Gardner, no relation to Ben Gardner, the guy with the boat. Hi, Rex. I hired a lawyer, and he sent in a demand within 2 weeks. They accepted my offer. How long till they sign their part? We are on the docket to go in front of the judge this Monday coming up. It doesn't sound like you're in New York, but you could be. If you're in New York, just because they signed doesn't mean that this hearing coming up on Monday would be one where they're going to go through with the agreement. Here in New York, the Workers' Compensation Board, under that circumstance, will close the case pending review. They'll review it, and then they'll give you another hearing date. So it's impossible to say. Usually, it's a couple days for papers to be signed by everybody once they're all done. What do I need to expect question-wise from the judge, and why would he deny it so? Again, I don't know if you're in New York or not. On a New York settlement conference, if it's a Section 32 settlement conference, the judge is going to ask you a bunch of questions to make sure you understand you're entering into an irrevocable agreement that cannot be reopened for any reason at any time unless all the parties agree in writing, and that includes the board, to reopen your case. And that will never happen because they're paying to close it. So they want to make sure you understand that you don't have to settle your case. You can continue to litigate. They're going to ask you questions about child support. They want to make sure you don't owe any outstanding child support in arrears. What does that mean? We run into this issue a lot of times. People say, well, I owe child support. I'll say, okay, that's fine. You might be somebody who's responsible to pay child support on an ongoing basis. We're only concerned if you owe it in arrears, if there's back money owed, if you stop paying for a while and they're coming after you for old money. If you owe money in arrears, they're going to take it out of your settlement and pay that off first. What else do they ask you? They want to make sure you haven't taken any drugs or alcohol that can affect your ability to make a reasonable decision. They go over the attorney's fees. They ask here in New York State, they ask if you watched that video that I pointed to on the wall before, which you don't see. Those are the things that they ask. They want to make sure you have an understanding of what's truly going on here and that you accept the ramifications of a settlement of your case. They are not there to make sure you get the most money possible. That's a big misconception. People think that the judge's job is to make sure that your lawyer got you the most amount of money that he could get you, and it's not. The judge's job here in New York State at a settlement conference is to determine whether or not your settlement is unconscionable or not. That's it. Unconscionable shocks the conscience. That you're settling your case for a basket of apples. That's unconscionable, depending on the nature of your injuries. They don't care about the value of your case. They don't care if it seems low or seems high or seems whatever. As long as it's not unconscionable, they're going to approve it. So it's not the judge's job to make sure your lawyer got you the most money. And a lot of people think that. It's your job to like the video if you find it valuable. That's your job. Complete system failure. Insurance disagreed with the IME, and the judge sent me to a neurosurgeon that agreed with orthopedic surgeon. Chances. That is a very disjointed question, and it sounds like something that was not in New York State, because if the insurance company agreed with the IME is the insurance company's doctor, unless they sent you to an impartial specialist. They need some clarification. Complete question failure. One love. What happened if you get terminated while you're in the working comp? What happens if you get terminated while you are in workers' comp? Depends on the nature and the reason for the termination. If they replace you while you're out of work because they need somebody to do that job, and then your benefits will continue. If you try to go back to work and you work for a day and they fire you because you were late that morning, well, now your benefits are in jeopardy. It's a case by case examinations required to determine what the ramifications are if you're terminated while you're on workers' comp. Actually, not only is that's a gold star question, despite my horrible Jamaican accent. Hi, Rex. How long does Medicare take to review your case and let your case settle? Medicare set-asides used to take months and months and months and months and months. And then just out of necessity, they started happening much quicker. You know, it's funny. On some cases, the insurance company tell you, I'm still waiting for my Medicare set-aside to come back. It's been 3 months. It doesn't take 3 months. Listen, sometimes it does, and I'm not going to, but usually they're relatively quick. Couple weeks, maybe a month or two is usually how long it takes to get a Medicare set-aside. Nick Reno Face. I got to make sure I'm not saying anything really bad when somebody throws a name. Nick Reno Face. I don't know. I see a specialist for my back injury. That happened at work. I drive for a living, and it was an auto accident. It was the other party's fault. My case was accepted. Just wondering what compensation will be. Where are you located, Nick? Is it a New York or a non-New York case? In New York, you're entitled to get your lost time paid for. You're entitled to get your medical paid for. If there's any permanent disability, you get that as well. So you're entitled to some stuff, my friend. Johnny Garcia had 2 lumbar fusions, one in 05, one in 18. I'm back to work after the second fusion. The judge found me 40% disabled. I'm afraid that if I continue working, I will damage the next level. I'm a semi-driver. When do you think is a good time to call it quits and retirement and get a settlement and retire? So, Johnny Garcia, you're hitting a nerve. Workers' comp is not a retirement plan. And when judges and insurance companies see this happening, they get really pissed. Workers' comp is not a retirement plan. You don't schedule it out to try to retire on workers' comp. You're entitled to workers' comp for disabilities that keep you from work. And if you're back at work and you're disabled, then your treatment gets covered. So it's not a matter of retirement. We don't retire on comp. You retire on your retirement. You retire on your pension. You retire on whatever you have in place there for retirement. We don't retire on comp. Workers' comp is only there for disability. From if you're unable to work, disabled from work, you can't work. If your conditions worsen or if a new condition arises, fine. But it's not a matter, you don't plan to go on workers' comp. So be very, very, very careful, Johnny Garcia. And even though I'm giving you a massive warning, it's actually a good question because a lot of people think like this, and I get it. But workers' comp is not a retirement plan. Felix, how many levels of denial? That should be like a book, like an existential. How many the levels of denial by Jean-Paul Rex. How many levels of denial do you need to reach before asking for forgiveness, a hearing, in order to get approval for surgery? If we're talking New York, it's 2 and then the third. So it's 3 if we're talking New York. Dorothy Roseberry. Hi, Rex. How long does Medicare? We answered this question, Dorothy. I think. Big mahalo from Hawaii. Mahalo. That might be the first time I've said mahalo. But it rolls, it flows. Why swizzle? Mahalo. I've never been. Love to go. Would love to go to Hawaii. I'm a fisherman. I love fishing. I'd love to go to Hawaii, put the family on the beach, do what you do, jump on a boat, catch me some whatever, bring it back, cook it up. Mahalo. Slim can hoop. Bad faith claim. IME was used as a spine referral to cut benefits. My treating doctor referred me to a spine specialist. The insurance used the IME as that referral and cut my benefit. I'm confused. Slim, explain yourself. DB Cooper. I'm 3.5 years in the New York compensation system, not comfort. I don't think you're comforted. I've had 5 surgeries. Fast forward, my lawyer submitted a summation for disability percentage. Does it sound like I'm near the end? Also, I have a $300,000 MSA. My lawyer is shooting for a 75% or greater LWIC. Does that $300,000 come out of my settlement? How does that work? It depends on the overall value of the settlement and what the insurance company chooses to do. Let me breathe. If you're settling, it really depends. The insurance company with an MSA that high, you're probably looking at them trying to do what's known as an indemnity-only settlement, or potentially annuitizing that $300,000. If they purchase an annuity, that $300,000 MSA is supposed to pay you for all of your treatment for the rest of your life. If you're 20 years old, that's a long life, my friend. They don't need to give you $300,000 today. They could purchase an annuity for $250,000. I'm making up a number. Save themselves a couple bucks and have that annuity pay you out over time and still satisfy that $300,000 overall long-term payment that needs to be made. But with a number that high, there is also probably going to be strong consideration as to an indemnity-only settlement and leaving your medical open. So talk to your lawyer. Your lawyer will have some more insight and information here as to what's going on and what you should be expecting. Hopefully, did you say you have a lawyer? Yes, you have a lawyer. So talk to your lawyer. But it sounds like you're in the home stretch, my friend. Scotty K just changed attorneys. He felt his old attorney wasn't aggressive enough. And does it take a long time for attorneys to transfer info? It takes very quick. When the board gets the notice of substitution, they put your new lawyer on notice. They take your old lawyer off. Pretty quick and easy. He wasn't aggressive enough. Kick their ass. Felix did some autocorrection. Thank you. Thank you very much. Marlon's in Pennsylvania, and I lost my holy shit. You see, I was rolling, making mahalo jokes and cooking tuna fish, and now you got a significant injury. I don't know what it's worth in Pennsylvania. Here in New York, 100% loss of use of a hand entitles you to 244 weeks of compensation at the total rate, which is 2/3 of your average weekly wage up to the statutory maximum. I gave you a bunch of info, but I don't know what it's worth in Pennsylvania. If that usually 100% loss of use of a hand, amputation of a hand, can bring you into the permanent partial disability category here in New York, and you can get an overall, changes you from a schedule to a non-schedule. So talk to your lawyer, Marlon. If you don't have one and you need help finding one, I would expect that you have one with an injury like yours. I feel for you, my friend. It's terrible. I'm sorry to hear that. Scott K, what'd you ask me before, Scott K? Transferring attorney's info. Complete shoulder surgery. I'm assuming you're meaning a shoulder replacement. I came down with carpal tunnel. Is it compensable? If your doctor thinks that it's a consequential injury, then yes, sir. Talk to your doctors. If one is due to the other, then yes. I should have known that Nick Reno face when I was asking where his case was in Nevada, Reno. I'm an idiot. I don't know the answer to your question of what the case value is. He has neck, upper, middle, lower back strain. He's seeing a specialist. I hope you have a lawyer. If you don't, we do have a great attorney out in Nevada that can help you out. And you need help finding him, you give me a call, 212-406-8989. If anybody needs any help, give me a call, 212-406-8989. Christian Contreras, that's a great pitcher's name. If they're trying to fire me, but I feel it's retaliation, does that make it safer for me that I reported it? I'm in California. I don't do those types of cases. Here in New York, they have the Division of Human Rights. In California, I'm certain that they have something similar. Talk to somebody who knows. Get a consultation. Try to get some answers there, because don't get pushed around. It's not cool. Complete system failure. I always want to do the robot when I see his complete system failure. Adjuster. I've been dying to do that. Never mind. Adjuster sent me to an orthopedic surgeon right across the street from the one that did the surgery, because the one that did the surgery left the system. My question is what it is. What it is. Again, you're welcome, but I don't know what you're asking me. Are they trying to poison one doctor against the other? I don't know what you're asking me. And Scott, we all feel your pain, brother. Terrible. If my job just let me go after a year on disability and I have my deposition and mediation in 2 months, can I ask for future compensation since my job terminated me? That's more of a improper termination question than a workers' comp question. Workers' comp here in New York State will pay you for your disability from work, future lost time related to your disability and your injury, but not necessarily if it's due to the termination. The nature of the termination, the reason behind it, factual question needs to be brought to light. Natalie with the comment of the day. Like and subscribe. Rex does an amazing job. Thank you. Thank you, Natalie. The Mets have been in the pooper the last couple days. We got to pick it up. Let's go, Mets. We have one question here on IG. Fear, no mission. Have you ever worked with Crum and Foster? If so, how are they on settling a case? I certainly don't want to put anybody down publicly, but Crum and Foster, they're okay. I've worked with them. They're not bad people. There's a fine line between the insurance companies and the attorneys that like fight incessantly for no reason versus the ones that are just doing their job. And it's their job to do their job. They're there to protect their clients, to protect their insurance company, and to not pay in circumstances when payment shouldn't be made. And I get it. And I respect that. And it's what they're there for. They're there to make the system wouldn't work without them. So Carpel Foster, not bad people. Nobody, I don't want to put my foot in my mouth. And that's why I try to be careful here. Yeah. Talk to your lawyer. Make sure your lawyer knows how to handle them and handle the system and get you the most that they can get you. Folks, we've reached our conclusion, and I thank you. I'm off to the Bar Association dinner, and I will make sure I say hello for each and every one of you to all the amazing people out there. Thank you, Mr. Bubblegum, Mr. Sir Bubblegum. He's benighted. He's with juicy fruit. Complete system failure. Call me, brother. 212-406-8989. And I'll try to help you out. With that, folks, thanks so much. You guys did great today. Fantastic. Next week. Next week is a short week for me. So how do you guys feel about doing a 2 p.m. live next week? I have a half day. I'll stay in a little bit longer in the afternoon, and 2 to 3. How about we do a 2 to 3? Sai, let's talk about this one, and otherwise we might have to, or maybe Tuesday. We could do a Tuesday afternoon. How do we feel about Tuesday, folks? We could do a 4 p.m. on a Tuesday or 2 o'clock on a Wednesday. We're going to figure it out. We're going to post the times. We're going to be with you next week. Hold on to those great questions. If you have any questions, you need to call me, please. 212-406-8989. You know me, Rex Sikofsky. And thank you so much for all the great questions today. Have a great rest of your week and stay safe, folks. Bye-bye.